a okay, there we go. Just a quick introduction. Many of you may not know who UC3 is, so just allow me to briefly share our mission and vision. Our mission is to deliver personalized, constitutionally grounded advocacy to ensure every Utah city, town, and county regains and exercises its rightful local authority. And our vision is a Utah where every municipality is empowered by tailored representation and restored constitutional governance. So I know it's a lot to do, but you know what? That's okay. It's better to have a big mission than no mission at all. All right. And just our brief agenda for tonight. I am so excited to have a fabulous keynote speaker for us tonight. And I am going to introduce him in just a bit. His name is Randy Parker, and you guys are going to get so much out of this presentation with Randy. I know it. And right after Randy's presentation, because he is our expert tonight, we're going to allow about a 10-minute or so Q&A. So as he goes through the presentation, think of some questions that you have, and you can put them in the chat. And then Heather, our wonderful client relations manager, will be keeping track of those questions. And then hopefully we'll get to answer those at the end of Randy's presentation. All right. Well, I am super excited to have Randy Parker with us tonight. His entire career has been rooted in the land, the people, and the policies that shape Utah's agriculture and water landscape. Randy's connection to this topic isn't just professional, it's personal. Raised on a working farm in Utah, he understands firsthand the critical role that water plays in sustaining agriculture, communities, and livelihoods across the state. He built on that foundation with advanced degrees in agribusiness and agricultural economics from Utah State University and went on to serve more than a decade with the Utah Department of Agriculture and Food, focusing on conservation and agricultural development. Of course, all these areas deeply tied to water use and stewardship. Randy later served as the CEO of Utah Farm Bureau, where he worked closely with lawmakers and national leaders to advocate for farmers, ranchers, and rural communities. Of course, often the center was complex water policy discussions. And more recently, he was appointed as the USDA Rural Development Director for the state of Utah from 2017 till 2021, where he continued to shape infrastructure and resource decisions impacting our communities. Simply put, he brings a great combination of real world, practical ag experience, policy leadership, and deep understanding of the challenges and opportunities surrounding water in Utah. So please help me welcome Randy, everybody. Going to end the slideshow, and I'm going to stop sharing for a second so that we can have Randy here. Oh, good. It's nice to see everybody here. Glad you could join us. So Randy, go ahead and unmute, and we're just going to have an interview here.
There, I think I took care of that.
Yep.
Yes, ready to go.
All right. All right. Okay. So let's get the foundation of water law covered for everybody, because sometimes it can be a little convoluted, a little confusing where we are, because it's different. It's different here in Utah than it is other places. So Utah has managed scarce water resources for generations. Talk about the foundational principles that have made Utah's water system workable, and why do those principles still matter today?
Thank you. Hey, I'm gonna go back and give a little bit of background, because Utah water law and where we're at today really begins with pioneer settlement, but going forward from there, when Utah became a state, we're one of only 5 states in the entire United States that more than 50% of the land within the state's boundaries is owned and controlled by the federal government. Now, that creates some very interesting dynamics. Most of those lands are mountainous. That's our mountains that are controlled by the Forest Service and the BLM, and that's where most of our water comes from. winter snow. So you would think no big deal there. That water runs off and it becomes the property of the state because the water belongs to the state by constitution. Well, 15 or so years ago, the U.S. Forest Service and the BLM began to require joint ownership of land or of water that ranchers and ski resorts were using on the federal lands. So here's the kicker on that. When they required joint ownership, if they then canceled a use permit like grazing livestock on the federal lands or a ski resort that had invested millions of dollars and they took away that use permit, under joint ownership, the water reverts to the federal government. Well, we were very concerned about that because in Utah, they've canceled about 70% of the livestock grazing rights in the state of Utah. Therefore, that water that originates on the public lands that's used for livestock has become under the ownership of the federal government. So that's real problematic. So a few years back, 10 or 12 years ago, I worked with a congressman in Colorado because they were very concerned. And we introduced the Water Rights Protection Act into Congress. And what that meant was, if passed, that was going to preclude the federal government from making claim on the state's constitutional waters. Well, we never were able to get that passed through the House and the Senate. And I just found out here recently that, bless her heart, Utah Representative Celeste Malloy has reintroduced that in this current session. So I'm excited that that's moving again. Now let's talk about those fundamental principles of water that you mentioned in your first question. Scarcity of water in the arid West led to an allocation system that is very different from most other areas of the country. Western water law, or the doctrine of prior appropriation, governs the use of water. Now, water is owned by the public, obviously that it is a public resource, but the water rights themselves are defined in state law, in the state constitution, and the water rights, the right to use it, belongs to, it started out heavily agriculture and is still very heavily agriculture, and it has to be used for beneficial use. I mean, that is the way it works. Now, as we were developing our water impoundments, dams and reservoirs and that, water companies often came together to represent the farmers or the community, and rights were allocated based on number of acres and what the use was for. So the principle of first in time, first in right is a very important principle for our folks to remember. That first in time, first in right meant that the first person to put that to beneficial use, even if it was held in a reservoir, that first person in time that beneficially used it had the first right. Then there are other subsequent rights, junior rights they're called, so that if we have a dry year like we've got this year, some of those junior rights will not be able to be used because it backs up to those first priority rights. So that's really important to remember. And that situation exists not for farmers and ranchers only, but for communities and throughout, because it is based on first in time, first in right.
Okay, that is really, really good for everybody to understand. And, just thinking about most of our audience members here are associated with or are local leaders in their own communities. And so how best would you say to continue to apply that core foundational principle to a lot of the things they're dealing with today, like development, for example?
That is, as I was thinking about three very important considerations. Mm-hmm. The Great Salt Lake's becoming a player in this. Obviously, our growth, we have tremendous growth. We are, if not the number one fastest growing state, we're in the top two or three. And we want our food and agriculture to be local. So we've got those three dynamics right now that are playing into the importance of how we utilize our water. So farmers have done a great job with the assistance of government, federal and state, to become more and more efficient with how they use the water. A generation ago, 2, 3, 4 generations ago, when I started in the agriculture community, let's say 60 years or more ago, we flood irrigated everything, which meant we had a ditch, we ran the water down the ditch, dammed it, flooded our field, it ran across it, ran back into the stream, and that's the way we utilized it. But we've become more efficient in how we use it, and we're doing a lot of sprinkler irrigation. We're still getting great production, but you know what? There's not as much in-stream flow to help downstream, which is included the Great Salt Lake. And that's happening in our communities as well. You know, we're very efficient in how we sprinkle the water in our communities here in the Salt Lake, Utah, Weber Basin, and all of that, but we don't return anything back into return flows that goes into the Great Salt Lake. So that's one of the problems that is generational that a lot of people wouldn't recognize. So from a policy standpoint,
yeah,
that can be dramatic.
yeah, absolutely. Well, and I can see just the different challenges that our policymakers do have to consider when it comes to water here in Utah.
Absolutely.
So let's follow up with this because this does touch on a foundational principle: water as property. So water rights primarily, right? So it often sits at the intersection of private rights, public need, long-term stewardship, just as you were describing. So how have we as a state historically done a good job of balancing those interests? Because right now we're seeing, I think we're coming up to another intersection where it's like what we did worked, but now we're coming to another level of our civilization where it's like, things have got to change.
Yes, there's no question about that. And at the same time, we have to recognize under Utah law and under the Utah Constitution, water rights are property rights. And so that is fundamental. So as we're thinking about that along the Wasatch Front, and we're transitioning water to other uses, there is a marketplace for water, and communities that are on this discussion know how to work in that. Of course, acre feet of water have become more and more valuable in the marketplace, but it's important that all of those that are involved in the policy world recognize Utah's Constitution. Article 1, Section 22 says, private property shall not be taken or damaged for public use without just compensation. So obviously, it's important for government to recognize that we can't just go out and take it because it's a public, it's a public resource. No, it's a private property right as well.
Right. Which is such an interesting intersection for our policymakers to work with, right? Because on one
Absolutely.
hand, they have a duty and obligation to protect private property rights of all their citizens. On the other hand, it's water. It's a public use, right? It's a public good. And so
Yeah.
how do we balance those two? So kind of going off of that topic right there, in your opinion, having done all these years in working with water policy, primarily with ag, but in so many different ways, and even serving on the Colorado River river discussions because that involves multiple states.
Yes, it does.
So, just curious, what reforms do you think strengthen a system like ours to help appropriately appropriate water? And what do you think reforms might unintentionally weaken that system?
Wow, that's the $1 million question, quite honestly, because in a really uh, difficult drought year, those 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 public needs are going to come to the forefront. And at the same time, to protect the integrity of the state's constitution and uphold it, we have to recognize that it's property. And so balancing that, my view is uh, government closest to the people can help make the decisions for how to make that happen without it becoming a taking. Balancing that is really important because it's fundamental property rights. But wow, ag water has been what has transitioned throughout our history, and it's taken place in a fairly positive market based way, and I would believe that that's what we need to continue. If anything, would move that to where these people that have invested their lives and their livelihoods into it, uh, that would be a constitutional catastrophe.
Would absolutely agree. I love what you said. Just sticking to those core constitutional principles, that really does make it work, and bringing in the free market principles that have worked in our state for, well, a lot of different things, but also for water for many decades, many decades. Well, over a century.
If you think about Utah agriculture, it is broad based. A lot of the water needs are in the northern 1/3 of the state, but agriculture is scattered around the state. Just as a side note, of course, agriculture is Utah's oldest industry. We have 18,000 farms and ranches in the state today, 90% of which are family farms. They generate $2.5 billion in direct economic activity, and they have an economic multiplier of 2 to 1. So it's about a $5 billion contribution, heavily focused in rural Utah. So 50,000 people have jobs related to this industry. So when people talk about the importance of wanting their food to be grown locally, it has a huge impact on our environment.
Yeah, no kidding. I just want to quickly remind people if they could remember to mute themselves. But not you, Randy. Um, yeah, no, that's amazing. I did not know that about our agriculture business. That's amazing. And I bet when we were talking before the webinar, I bet when you come across people who say, even considering agriculture or giving agricultural preference is short-sighted. When people say that, they don't know the half of what they're saying.
Well, and thank you for that. That's a nice lead in, because there are those that think that growing alfalfa is a waste of water and a waste
Mhm.
of a lot of things. Well, alfalfa is a foundational product that we grow here in Utah. It's then used for dairy cows, for the milk and the cheese that we enjoy. It's also used for sheep and cattle. So, it moves up the food chain, so to speak. And so it's not just the water that's used for producing alfalfa hay; it's for everything that it produces that makes our lives enjoyable. Uh, I certainly enjoy a good barbecued steak and a glass of chocolate milk.
I am right there with you. Okay, so I want to try to give some time if anybody has any questions. So again, if you have any questions for Randy, please put them in the chat. Um, but Randy, if you were to give counsel to mayors, to commissioners, to council members, and to planners all across Utah, what guiding principles would you want them to remember as they make water related decisions?
What I would like to do is remind them that sometimes politics and what is the flavor of the day, we make policy decisions. And I know the Great Salt Lake right now has a dramatic need. And a lot of the discussion is revolving around those needs. But I'm old enough to remember the mid 1980s when the Great Salt Lake was expanding to the point where it was flooding the airport and some things like that. And we put a big pump in out in the West Desert, and we literally pumped salt water out of the Great Salt Lake into the West Desert. Now, looking back 50 years ago, or 40, 40 to 50 years ago, that short-term decision has had long-term impacts. And it's like what was the need and what was the value? Well, the value was economically we had to, in fact, we had to do that at that particular time in order to save our airport. But boy, since then, it's been it almost looks like it was money that was not well spent and public policy that was not well thought out. So we have to look at not only the short-term ramifications, but the long-term. And I'm thinking again of the Great Salt Lake. Under water law in the state of Utah, farmers and ranchers can idle their water for a short period of time. But under Utah's water law, and they could send it down to the Great Salt Lake. But if it's not put to beneficial use for a period of, I think, 2 years or 3 years, I can't remember if law has been changed. But if it isn't, they forfeit that water right. And so there has to be a mechanism to protect that in the short term while they're helping the Great Salt Lake that don't have long-term adverse impacts.
Yeah, no, that is excellent wisdom, Randy. And I hope that we can give this to all of our mayors and city council members and commissioners, because it's very difficult when you're faced with a present crisis to think beyond the present crisis and what will these current policies do 20, 30, 40, 50 years from that time frame. So I really appreciate that. We actually do have, I think, a couple of questions. Well, we might have time for one. Okay, so
Give it a shot.
this is related to a specific bill that passed this year. It's Senate Bill 284, which is it was one of the biggest, it was the nexus between land use and water this year. It was a very important bill that was high priority for leadership in the state. So the question is, should developers have to bring their water to their development? What do you think about that?
It seems to me as they are investing in and building homes and so forth, there has to be a mechanism to provide the water that is necessary. I've heard of nightmare situations where a builder built in a community that didn't have the water to provide to it. So I would say that a builder would have to at least identify the water for what they're building in conjunction with the community because it just doesn't make sense that that you build, and it's the old adage, if you build it, that it will come. Well, you know what? In an arid state like Utah, that's not always the case.
It's true. And I was thinking too, and especially in relation to this bill, I was thinking, well, what happens when a community has, let's say, plans to build a community center? And that community center is, of course, going to require a certain amount of water. And then you have excess developers coming in, new ones. They're saying, hey, we really want to build here. And how, anyways, it's a lot of juggling and wanting to see which is first, which is best, and which is more beneficial for the community, but also, do we
Absolutely.
have the water? And okay, I have one question that I heard from he's a state planner. Anyways, he knows of a community where this is down in southeast Utah, by the way. It's a community. And as we mentioned, like our mountainous regions and such often make some barriers for us to get the water. But they said they have the water, but they just can't get to it. And so I was just wondering if you could explain a little bit about that. It might go into the infrastructure discussion.
Well, that's one of those dynamics where a state that has almost 70% of its land base owned by the federal government, and the BLM and the Forest Service haven't always been good neighbors. And if you've got water originating on the Forest Service lands, and you have the ability to then bring that down to deliver to a community and possibly even grow that community, it may take years in order to get permits either accepted or rejected by the federal government, because if this is going across federal land, the state has no control over it. And that's sad that the local communities that do have those water rights sometimes don't have the legal mechanism to get it delivered. And that's because of this dynamic of federal ownership, state ownership, private ownership, and communities that have their own community lands. It creates a really difficult situation. And I'm sorry I went a little long on that, because I have spent a career preaching states' rights in Washington, D.C., and at our state capitol. And I've had the honor of actually testifying before the United States Congress, U.S. House of Representatives, 5 times on states' rights, states' water rights, and the problem of the federal government holding public lands in perpetuity when they were meant to be returned to the states under the equal footing doctrine. That was an obligation that the federal government made to the states, that they would return those lands for the states to make determinations. And they have lied to us, and they've not held up that responsibility. Sorry to get a little political here, but I have a lot of passion and have spent a lot of time in Washington, D.C. on that issue.
No, I hear you. Like you said, in a state where 60-70% of the land is owned by the federal government, this
Yep.
is a very real reality that we work with. And
Yes.
hopefully, one of these days, we will make some headway on gaining back what's rightfully ours.
Yep. The equal
So,
footing doctrine was in
doctrine.
place for our benefit, just like it was Missouri and Pennsylvania and Florida, and we have never gotten our birthright.
Oh boy. Okay. We have definitely got to do some more work on that. Well, Randy, I want to thank you so much for your time tonight, and
Thank you.
you're welcome to stay and listen to the remainder of the presentation. I'm going to just go ahead and start sharing again. But Randy, this was awesome, and there were a couple of questions that people asked that you didn't get to. Would it be all right if I sent them to you afterwards, and you were able to email them, and I could send them out?
Sure, that would be fine.
Okay.
And I'll hang on and see where you're going. It's
Okay.
very nice to get acquainted with you and your organization. And you've heard my philosophy: government closest to the people is the best government.
Oh, we agree very much so. We definitely agree on that. All right, sir. Thank you so
Thank
much.
you.
All right. Okay, folks, I'm going to share my screen and we're going to start sharing here. And I'm going to start from the current slide. From the current slide. From the current slide. There we go. Okay. All right. So moving on. That was awesome. Okay. Let's talk about the legislative recap. So now that you have a nice foundation of water law, there's still a lot, but water and land are absolutely tied directly to everything that we do here. And so we couldn't not talk about water policy when we're focusing on housing policy as well. So I'm just going to walk through very briefly what happened. Hopefully, you guys have received our legislative wrap up report. Heather sent this out to everybody who's on our mailing list. This is our short version, but we also have a longer, detailed version that we can also send. And we'll send to all of our participants today. And we recently completed one that was specifically for water policy. So an addendum, although it's pretty long too. So addendums seem to be short, but this one's kind of long. So anyways, you guys will get that as well. But we just want to make sure that you're informed so that you can make the best decisions for your own communities. So, housing policy, water constraints, and local authority. Remember, everybody, this isn't just about one bill. And I know many associations like to focus on each bill singularly, but it's really important to look at how they all work together because they're supposed to work together. And even if they're not supposed to, they still do. And so we want to look at how these work together and how those decisions must now be defended constitutionally or not defended. Um, Again, like I said, not one major change, but instead it created a layered restructuring of local governance through multiple coordinated bills. Again, individually, these bills may seem manageable, but together they absolutely reshape how local governments approach housing, land use, water, and all decision making. So, the constitutional foundations that we're going to focus on for this. And of course, I hope you have a copy of our state of Utah Constitution. I know Randy does. I know Bern does. And I know Jen does. But if you haven't gotten one, you guys can get them off of Amazon. They're not that expensive, but I highly encourage you to make sure you have a copy of our state constitution and our federal constitution. They're very important. So the first Article 1, Section 1, this protects the ability of people to use property and pursue safety and well-being, right? Article 1, Section 22, Randy mentioned this. This protects private property from being taken or damaged without compensation, which is very interesting that we have damaged in our Constitution. It's very subjective, but I think it was very smart, very wise of our founding fathers to put that in there. And then, of course, Article 11, we talk about this a lot. And this, of course, goes to our local government authority and what local governments are supposed to have charge over. So every policy change we discuss today should be viewed through these lenses. Like if you don't wear glasses, I'm sorry, you won't get this analogy, but I wear glasses and I have to put my glasses on in order to see clearly. And so that's what we do with our constitutions. We have to make it the choice to put them on, though. All right, housing policy is no longer just about zoning and density requirements. It's not just about that. It's now a system of state directed frameworks that local governments are expected to implement, often with conditions that are tied to funding, especially infrastructure funding, water availability, that's especially true with SB 284, and compliance requirements. Also SB 284 because they put ADUs in there now. So everybody gets to have ADUs in their community now, whether you want to or not. Okay, so I'm going to call out some specific bills. There are more in our reports, but again, I didn't want to keep you here all night. We could go for a whole day long conference discussing all of these bills, and possibly we should because they each take a good amount of time to fully understand. But let's just do some of the highlights. So HB 68, Substitute 6, this is the Housing and Community Development Amendments. This bill requires cities to implement specific housing strategies like rezoning, higher density, parking reductions. In simple terms, it gives the state a stronger role in shaping how your community grows. Now, some people would say that bill was just a simple recodification. It was not. It introduced many new policies within that bill. Senate Bill 284, local land and water modifications. This is definitely one of the most important bills. It ties water planning directly to land use decisions and requires cities to follow state-defined frameworks when approving development. And that even includes new restrictions on planning commissioners, which I'm actually concerned that it may actually be possibly violating some federal First Amendment freedom of speech provisions. I'm concerned about that. But again, we can have discussions about specifics on these bills at another time. HB 457, the county governance modifications. So this bill introduces automatic annexation mechanisms. So boundaries and service obligations can shift with less local control. Now, it seemed like that bill was mainly to get rid of donuts. And if you don't know what a donut is, basically you've got like a whole, like maybe a city surrounding one little piece of a county owned parcel in the center. And then it makes it so that little parcel has to go to either municipality, on either side. It's kind of it's an automatic annexation. And so again, annexations are very, those are very much local decisions. And so now it has become a state decision. HB 65, construction code amendments. Now, this again, we would understand these just to be simple amendments. We're just updating code. Not really. This actually expands statewide control over construction standards, limiting local flexibility in your own building requirements. I just have to say that's a little concerning because I think about, if you guys remember, and you probably are more familiar than I am, but the small town of Magna seems to have a lot of earthquakes that originate there. It seems to be a seismic hotspot. Why wouldn't they want to make sure that their buildings maybe are built to a higher standard when it comes to earthquake prevention and such than maybe my area where we don't typically get very many? I'm just asking that question. So anyways, and then of course there is the House Concurrent Resolution 6. Again, we got a lot of pushback for asking our legislators to reconsider this one because it was just a resolution. But as we know, there is a resolution from the previous year, from 2025, that guided 14 of the bills that came through this year. And so HCR 6, it's a signal. It signals to the legislature in the future that it intends to continue pushing statewide housing coordination and likely more preemption in the future. All right. So basically, what do? All right. They reduce your flexibility. They increase state direction and discretion, and they require specific actions. They also make it harder to tailor your decisions to your infrastructure, your water supply, and your community needs. It's not about eliminating local government per se, but literally it is reshaping the role that our local governments play. And that's very important for you guys to understand. Okay, let's talk about a few more bills. House Bill 492. This is an infrastructure and housing amendments bill. So this also created a new funding tool. It ties infrastructure funding to housing compliance. So if you want that infrastructure funding, those low interest loans, then you're going to have to plan and do and create the things that the state is telling you to create. And that's, well, actually, there are precedents where that can be considered coercive. So, anyways, take it as you will. Also, House Bill 507, the Regional Development Project. So this creates development zones and redirects tax increment revenue. Okay, that's a really important thing to remember, the redirection of this revenue. Okay, Senate Bill 278 and Senate Bill 39. These both expand development financing structures controlled at a broader level. I know that was a lot to say, but basically, cities and counties, local municipalities, they will still carry the costs of growth. So think about the infrastructure costs, think about the police, think about the fire response, think about schools, right? I know those are districts, but they will still carry the costs of growth, but you will lose control over how that growth is funded because of these redirecting tax financing mechanisms. Okay, so administrative shift, basically one of the biggest shifts, it's structural. It's structural. So local decisions like zoning and development are increasingly treated as compliance exercises rather than policy choices. In simple terms, our local governments are starting to move away from decision makers to administrators of statewide programs, which is an interesting thought. And I will tell you that is absolutely not constitutional. That is not the way we were set up to go or grow, by the way. All right, let's talk about a couple of other bills here. Oh, and another one again, HB 60, the Water Rights Amendment. It changes protest and review processes for water rights, making it harder to challenge decisions. And also Senate Bill 284, here it is again. It also limits local discretion in land use decisions, and it takes away, it basically shortens the time that you have to protest a land use decision. It's down to, I think, only 30 days now. And that was lauded as a simple cleanup, but not really. It's concerning because this is due process. This is very important federally in our federal constitution and our state constitution. So it basically means less time for public input, fewer opportunities to challenge decisions, and more pressure for our local governments, especially our city councils, to comply quickly, like that. All right. So water. Water is always, and Randy, you'd probably agree with me. Water has always been a limiting factor here in Utah. I think it always has. Yes, absolutely. But it's become very evident in our policy now and the way that the state is telling our local governments that they need to plan and grow. And so the biggest shift tying everything together is water, and it is now the controlling variable in housing. So again, like Senate Bill 284, it requires cities to prove water availability, use the state planning models, which are going to be coming through the state engineer's office, and then tie water directly to land use decisions. So that's a little bit of a different shift than what our local leaders have had to deal with before. Okay, so new questions. New questions for local governments to answer. This is one of the most important shifts. Before 2026, the primary question was pretty straightforward. Can we approve this development? Local governments have the discretion to weigh in infrastructure, community needs, and their growth. After Senate Bill 284, the question changes, at least operationally. So now you're being pushed toward something different. Does this align with state water planning models and the state engineers' projections? Because SB 284 requires water demand projections, state-defined planning standards, alignment with broader water availability frameworks. So in practice, decisions start to look like compliance checks. But this is really important. That's not the only question you're responsible for, because every single one of our local elected officials, our state elected officials, every single elected official has to take an oath to uphold the Utah Constitution and our federal Constitution. And so the question you always have to ask is, can we defend this water decision constitutionally, right? Because even if a decision aligns with state planning, you still have to avoid unconstitutional exactions or takings. Okay. You still have to respect Article 1, Section 22. And this is the local government side. This is where this is actually very unfair because the state has the requirements and they're making the local governments do these new requirements, do it this way. And yet the local governments, when they still have the decision to make, they also would be the responsible party for upholding a person's constitutional rights. And if they violated those, that person could then come after the local government. They would not necessarily be coming after the state. That's important. Okay. So we're seeing a state-driven compliance framework. And we also see this local constitutional responsibility. And this is where you guys are operating right now in the middle of these two pressures. And it's not an easy place to be. Okay. All right. Cumulative effect. So the real issue in plain terms here, each bill adds pressure. Each layer reduces flexibility, and together they all restructure your authority. And local governments are gradually shifting from independent decision makers to state conditioned administrators. These changes raise several constitutional concerns. Property rights, especially takings and exactions, due process, the reduced ability to challenge decisions, which is, that's so fundamental for us just as Americans. And it's repeated in our state constitution as well. It's very important. Local authority, super important. The erosion of home rule and emerging public trust conflicts around water, because as we learned, water is also public. Everybody has to use it. And when one person uses some, that means there's less for somebody else. So these all These things all come together and they're not just theoretical. They all will show up in real decisions. So, what can you do? I know I gave you a lot of not so great news, but don't panic. So, the right response is not to panic, and it's not passivity either. The right response is disciplined preparation. Okay. So, let's talk about what you guys can do and what you can encourage your communities to do. One, adopt constitutional resolutions. You may not think that you need to simply repeat what's already in the Constitution, but that's actually a very wise policy decision to do. And we would highly recommend that you do that, especially reinstating the constitutional principles that we mentioned here tonight, Article 11, Section 5, Article 1, Section 1, and Section 22. Was it Section 7? Anyways, repeat those and it actually makes for very good policy. It's amazing how the constitutions work that like that. Build an implementation matrix. So know what's required versus what is optional. And we've actually done that a little bit for you guys in our wrap-up reports, just so you know. Water findings. Just document all your decisions. Stress tests. This would also include financial stress tests when we talk about some of these, the tax increments financing tools that are being used to basically reroute tax revenues to another authority and not the local authority. And yet the local authority will still have to be responsible for local services. So stress tests just like that. Exaction protections, like don't overburden the property owners. You guys have to be very conscientious about that. And I would just say document everything. Development agreements, make sure you clarify those, update your bylaws, your codes. If you don't have a land use checklist, then I know you're going to have to, if you don't already, but I would highly recommend making sure that everything is on there. Record keeping, just make sure that you're always keeping everything recorded, and coordinate regionally. Hey, wouldn't it be a great idea to maybe join an association that's actually sole purpose is protecting your local authority through the lens of the Constitution? That would be a great idea. Okay, final takeaway on these bills. So, guys, don't worry. Local governments still exist, but their role is changing and the preparation is key. Okay, the future of local governance will depend on how well this preparation that we just talked about is done. And it's totally possible. It's totally possible. Whether or not, whether we can defend how we grow constitutionally, fiscally, and sustainably. And so let me just remind you guys a little bit about us. So our approach is a little different. I just want to let you know what we can do for you. Because I know a lot of you have people who, a lot of cities and towns and counties already have people who read legislation and track legislation, and you probably already belong to associations who represent you. And that is important, but we do it a little different. Most organizations are really good at telling you what a bill does, but we like to focus on what that bill does to your authority. That difference matters, especially as I just explained in a session like 2026. So at UC3, everything starts with the Constitution, not policy outcomes, not program goals. We start with Article 1, right? Article 11. Your authority as a local government. And we ask different questions than most. We don't ask, does this policy help? Rather, we ask, who is going to be making the decision? And is that constitutional? As our analysis showed this year, the biggest risk wasn't any one bill. It was that cumulative structural shift, the multiple bills moving authority upward all at the same time. And so, what do we provide? We provide practical help for you. We help you understand the full impact of legislation collectively, not just individually. We help you build implementation matrices so you know what's required versus what's optional, help you identify constitutional risks early before they become legal issues. We help you to draft policies and resolutions that protect your authority and provide education and training for the leaders, the local elected officials, as well as their staff, so that everybody can be on the same page and everybody can be making those informed decisions. And in plain terms, right, it means that you're not just going to be reacting to your legislation. You're actually going to be protecting your authority, reducing your exposure to risk, and strengthening your position for future decisions. Because the reality is, as I explained before, you're still responsible for these outcomes, even as the structure around those decisions is changing. So I want to thank you all for being with us tonight. And if you have future other questions, follow-up questions, or if you would like to invite us out to your community to do a presentation like this or something more specific, maybe more detail on certain bills, we are happy to do that. Reach out to Heather. She is our client relations manager, and hopefully you guys have been getting her emails. She's the one who emails out our newsletter, and she will be emailing all the follow-up materials to everyone here. So make sure Heather at UC3.org is on your like good to go list, or double check your spam and make sure you move her emails out of your spam box into your inbox. And then my email address, Sarah, Sarah at UC3.org. I am happy to answer your questions. And I'm just so thankful that you guys joined us tonight. And good luck with everything. And we are here to help. Thanks, everyone.